Hi, everybody, and good morning. Welcome to our educational webinar, Essentials for Estate Planning, Wills, and Trusts, where it is smart planning for today, tomorrow, and beyond. According to AARP, only 71.6% of Americans across all ages have a will, which is not a lot of people. Around that, 30% of the people from the ages of 65 and above are the only ones that have a will. So why don't they have the will? There's two main reasons. One, they just haven't gotten around to it. They just love to procrastinate. That's what we love to do. And the second reason is a lot of people don't feel like they have a lot of assets to go in a will. So today you're going to learn why you need an estate plan and a will. The challenges and common mistakes to avoid when making one. 3, what happens beyond death. And 4, some trust strategies. My name is Ruby Pellegrin, and I am a legal assistant and the office manager here for Attorney Arthur Brown, and he will be going over all these reasons for you today in our webinar.
Thank you, Ruby. Greatly appreciate that. Who am I? I'm an estate planning, trust, and probate law specialist. I've been certified since 1993. One thing that's unique about me also is I'm VA certified, so I do assist a lot of veterans, and I basically help them with aid and attendance. One thing about estate planning is you need to have more than planning for death. You need to plan for what's called elder law. What happens to you if you become incapacitated? My oldest client's 113 years old. She has passed on now, but she's been a client of mine for the last 25 years before her death. And we did a lot of planning for her, and she was always prepared. I've been doing estate planning for about 33 years, and I would estimate that I've done over 6,000 estate plans in the last 33 years. So basically, I want to say is our practice, my practice is basically limited to estate planning. We do basic and advanced planning. We do trust administrations, and it's more than just passing at death, but also during lifetime. What happens if you become incapacitated? I also do probates. That's all part of my practice as well. We do a lot of blended families these days, actually. So basically, we want to talk to people on how to maybe not disinherit one of the spouse's children. We also do asset preservation, and basically, we're going to talk about if you do need to go into a facility, for skilled nursing, then how can we preserve the assets, not only for yourself, but perhaps your surviving spouse, as well as your family. We do elder law, as I said earlier. We do Medi-Cal and VA planning. We do charitable gift planning as well. We also talk about planning for gifts during lifetime, as well as at death. So my practice is really, once again, very limited to estate planning. So in my practice, we want to say we have a full service estate planning office. Basically, we're really there to take care of you. We meet with clients 3 and 4 times. You have myself. You have my associate, Eric Chow. We also have Ruby, who you just met. And I also have my other legal assistant, Elizabeth Mendoza. I've been a resident of San Diego for the last 55 years. I've been married for 26 years. I really have the yin and yang of a relationship because my wife, Rebecca, is a certified nurse midwife at UCSD Hospital, and she's delivered over 2,600 children, babies. I have a son, Alex, who's age 20. He attends SMU College in Dallas, Texas. He just came back. But what's really interesting about my practice is that, or way I grew up, was that my mother was a wedding coordinator. My dad was a divorce attorney, and then finally I deal with passing away at death. So basically, we birthed them, we married them, we divorced them, and now we also take care of them in the elder age. So we're going to talk about estate planning, but we want to divide that up. We want to talk about what is an estate. And too often I hear people say, I don't have an estate. Why do I need to worry about it? You really need to. I will say, when my son turned 18, he doesn't have much, but it was very critical because we're no longer, since he was turned an adult, we had a will prepared for him. We had a financial power attorney. We have a healthcare power attorney because we want to be able to step in when he couldn't do it. And we never know. We don't expect anything to happen to him, but it's there just in case. But basically, an estate is all the wealth you've accumulated during a lifetime and then at death. Unfortunately, someone's worth more dead than alive, and sometimes people die young and they have life insurance. It comes to an estate. You got to plan for that. So who needs an estate plan? Well, basically, once you become an adult, you can do an estate plan. And I did do one for my son when he turned 18. I also did a estate plan for a number of his friends because they thought that it was very important to have a will, a financial power attorney, and a healthcare power attorney. You got assets. It's got to go somewhere. What's critical is how much planning you do. And if you got real estate in California, it's really, really important to get that in the trust. Also, if you have out-of-state real property, you got to get that in the trust. And a lot of young people who are married have young children. And once again, you got to direct it where it goes. I will make one comment. Age of majority is 18. Not too many people think at 18 their son or daughter can actually handle the assets. You may want to delay it. And a trust we're going to talk about will be an ideal vehicle to be able to pass it. I like the earliest is about 25 personally. So estate planning is more than planning for death. Estate planning is really the creation of your wealth. You're working hard for a living, or you're working right now, and you're going to preserve assets. You're going to retire. And how long do you want to keep your assets? As long as is possible. So when will that be? Who knows? I wish you all a long life. When the time comes, may it be quick. But we all do become incapacitated in general before we die. The question is it going to be days? Is it going to be weeks, months, years? Basically, we need to have planning. And as an estate plan lawyer and elder law attorney, I'm finding myself into preservation to be able to help people out. And then ultimately, we want to pass the estate on. And once again, do you have minor children? Do you have assets that need to be distributed to one child or another? We need to basically talk about that. So what are the objectives? What is the planning? The who, the what, the when, and how? The question is, who will receive your assets? Well, it's real simple. I have one wife. My wife gets it. But if my wife passes away before I do, then it goes to my son, Alex. And basically, my son, Alex, will have the assets. But wait a second here. What assets will he receive? Do I want to give everything to him? Do I want to give it to other people? Do I want to go to charities? These are things that we want to discuss. When should he receive the assets? He is going to turn 20 this month, actually. And I don't want him to have the assets too early. I'm afraid that he won't use it constructively. I don't think he'll do wisely. I'm delaying it out to age 25, well, a minimum 25. I actually half at 25, the other half at 30. But he cannot manage the estate. And I must admit that if my wife can't take care of me, if I become incapacitated, and if she becomes incapacitated, I don't want him to step in. So I need to look for a trustee. And we're going to discuss this later on as to who should be your right trustee. And really, estate plan kind of evolves. Things change. So you might have done an estate plan some time ago, and you basically have your kids grow up. I will say the vast majority of clients' kids actually do become the trustee, but not right away. So what are the challenges? We basically have 5 estate plan challenges here. We have attorneys. If it's not done properly, guess what happens? Who wins when you go to court? It's not the family, it's the attorneys. So basically, typically when I do estate planning, when someone dies, it's only one attorney involved. That's myself. You really want to avoid probate. We'll talk about this as well. There's going to be an issue of estate or death taxes. Also, there's going to be an issue of long-term care. We'll talk about this real soon. But the other challenge is the family. If you don't do it properly, who's fighting? I have seen clients who basically do not talk to their siblings these days because it wasn't done properly. We really want to do your estate plan properly so that your family will stay together. So here are the common mistakes. The human nature of procrastination. Basically, what's going to happen is I'll do it tomorrow, and tomorrow never comes. Some of you got smart and you did an estate plan, but you're using older, outdated documents. It's time to update those. When you do estate planning, it's actually 2 parts. If you're doing a trust, you got to create the bucket, but then you want to transfer assets into that bucket. If you don't transfer them in there, you might have a probate. The other thing is that you need to basically update your beneficiaries on your life insurance, your 401ks, your IRAs. Make sure you have the right one. Typically, I prefer to have a spouse first and children second, but that's not always the right way of going. You may have the wrong trustee or executor. You may have had them right initially, but as things change, your daughter or son who lives right across the street from you, that's a perfect person. But then they get a new job. They're in Europe now. You don't want to use that person. Or they unfortunately file for bankruptcy. It's probably not a great idea. And then ultimately, you might not have anything. And so basically, having no estate plan is not the best way of doing it. You need to have something. So what happens to you if you become incapacitated for an extended period of time? Have you thought about this? It's really important to really have some ideas as to when you need to do this. You need to do it before you become incapacitated. So one thing, if you've done nothing, absolutely zippo, nothing, you're going to have to end up in court. And it's called a conservatorship. Other states call it a guardianship, but in California, if you're under 18, it's called a guardianship. Over 18, it's called a conservatorship. If you've done nothing, then the courts will appoint someone to look after you, to manage your affairs, not only for your assets, but also for your person. So some of the techniques to avoid having to go to court is basically we have some healthcare issues. And so you hear the term living will, and we have a term called posts. And basically, these are kind of wishes. If I'm on life support systems, I don't want to be maintained on them. So basically, it allows you to put your instructions down onto paper and have people you trust basically follow them. Another big document which I can customize for clients is to basically have a durable healthcare power of attorney, or sometimes we call it an advanced healthcare directive. These allows you to appoint someone else to stand in your shoes to act for your body needs. You've heard of DNRs, and basically it's another way of doing it. If you go in the hospital, you can get a doctor's order that says, do not keep me on life support systems as well. So these are all part of the healthcare issues that we have to address. What about financial? Estate management. Well, you may open an account with a son or daughter with your spouse, and basically allows one of them to be able to pull money out. You might have a financial power attorney and allows you to have someone step in when you can't do it yourself. It's called a durable financial power attorney. It means lasting. Being lasting allows for someone to step in your shoes to act for your financial needs. I think a better document is a living trust. A power of attorney ceases at your death. A living trust is helpful during lifetime as well as at death. Allows you to pick someone you trust to be able to take care of your assets. Now, I will say not everything goes into living trust. An IRA or 401k does not go into the trust, so the power of attorney would be something you would want to use. Long-term care. You know, I'm a psychology major, actually. I was always interested in basically people who become incapacitated. And so basically going into estate planning was a great way for me to do that. Why? So what happens to you and your estate if you need long-term care for an extended period of time? So basically, here's some issues here. Basically, you may stay at home. You may have sufficient amount of assets to provide for care 24/7 for you, or less than that, maybe 7 days a week, but maybe 8 hours a day. You might have to go into a skilled nursing facility. You may look at a boarding care facility. Maybe you move in with a son or a daughter and stay in the child's home. I will say my dad, 2 years before he passed away, he actually lived with me, and I enjoyed that immensely. Remember, he was a lawyer, and it was really interesting because we did hard challenges as fellow lawyers, but we made up like good lawyers as father and son. You might be private pay. You might have long-term care insurance as an option. Some people have looked into reverse mortgages, and some people looked into qualifying for what's called Medi-Cal, or some states called Medicaid, and some of those who are my clients who are veterans, basically we're looking for veterans aid and attendance benefits. So now, after you become incapacitated, now you pass away. What happens to when you pass away? Well, first off, people ask, will there be a death tax, or is there going to be inheritance taxes? As a general rule, there's not going to be, for most clients, if you die this year, 2020, and probably 2021, that there won't be an estate tax. The exemption amount's gone way up. In 2010, the amount you could pass without death taxes was $5 million. The law has changed now. And under current law, in 2020, you can pass $11,580,000. And if you're a couple, you can double that up to $23,160,000. So today, most clients really don't have an estate tax issue. But I will say that we have some changes back in Washington. We also have changes in the law that will sunset in 2025. And basically, we'll see what happens if that basically doesn't get changed before that. Why are we here? What are we concerned about? What happens at death? The general rules, you're going to go to probate court. And I'm going to tell you my general rules, we want to avoid probate. My workbook, which you can download yourself on the handouts, actually is to avoid how to avoid probate and conservatorship. So I will have you take advantage of that. So the general rule is the probate is the administration, it's the passing, it's the distribution of your assets or an estate by a court pursuant to the terms of your last will and testament, or by what says, if you don't have a last will and testament, intestate succession. That means if you die without a will. So here's the problems with probate. Probate is expensive. If you go to my workbook and you look at page 3, I want to tell you right now, you can see what costs would be kind of close associated with your own situation. But probate is on a gross value. You add everything up, the house, the car, the stocks and bonds, the furniture, place, you get a top dollar value, and you don't subtract for encumbrances, liens, and deeds. Basically what happens is you use the gross value. On the first $1 million, the fees, the costs, or the fee is going to be is $48,000. The cost is going to be of another couple $1,000. So really it's about $50,000. Now I will say, who is your executor? Normally you put your spouse first, a child second. And a lot of times the fees will be waived by a spouse. Why? If they took a fee, they got to pay income taxes on that. So a lot of times they will waive that fee. The new law for 2020 through 2023 is that basically you could pass an estate Without probate, if it's below $166,250,000. So basically, you can have some things left outside of the trust and still not trigger probate. Probate does take a long time. So at least a year typically, or more. The other thing that I find really offensive is that most people tend to be private people. There's a lack of privacy. We have a very public court system. What happens here is that someone dies, they open the newspaper, they read the obituaries, and they're finding that your friend down the street had just died. Now you go to the court website and basically, look them up and see who they are, who their spouses, who their children are, what kind of assets, what kind of creditors are out there. Actually, what's interesting is that I don't need to be local here to find out who died. I can be in northern Maine, and I can go to the San Diego Union website and find out who died through the obituaries and get all that same information as who you are, who's your spouse, what kind of asset you are, what kind of debt you have. So basically, I find a lot of people really want to avoid that. So basically, we're going to talk about techniques. You can die intestate, you can die with a will, you can die with a living trust, or jointly held property, or you get some kind of contract. So if you die intestate, what does that mean? That means basically you die without your own personal will. Does that mean you have a plan or you don't? Well, you don't have your own personal one, but the state of California has said that you do die with a plan. And you may not like what it says. So basically, if you got community property, it goes to your spouse. If you got separate property, part goes to your spouse, part goes to your children. If you have no spouse, goes to your children. You have no children, goes to your grandchildren. You have nobody below you, goes to your parents. You have no parents, goes to your siblings. If you have no siblings, nieces and nephews, there is a plan for you. It still has to be probated, and there's still the fees and taxes, but it also has some time delays. So you should have at least something. And the simplest will is basically one that you do yourself. And if you want to take a piece of paper out and write out your wishes, it's called a holographic will. And you do that in your own handwriting. And you sign it. And in California, that's valid. You don't need it gated. It used to be, but not anymore. And you don't need witnesses for a holographic will. So basically what happens here is that sometimes I tell clients, they give me a call, Arthur, I've got to see you. I'm going to Europe this weekend, and I need to have a trust. I said, I don't have time to do the trust for you. So here's what I'd like you to do. Take out a piece of paper and write out your wishes on death. On my death, I leave my essence to my wife. If my wife is not alive, then to my children. I leave it to the oldest child as the executor, and so forth. And then you just sign it. If you type it out, and sometimes people believe that typing out is more official, you need 2 witnesses. So basically, if it's typed out, it's not in your own handwriting, it's going to have 2 witnesses. The problem is that I asked you, do you have a will? It's interesting because Howard Hughes, people who knew him said he had a last will and testament. And basically, he died, and in Nevada and Las Vegas, they had about 27 wills submitted, and all 27 were thrown out. You got to make sure people find your last will and testament. You may have jointly held property. It's not uncommon to see husband and wife have property as joint tenancy. What does that mean? One dies, goes to where? The survivor. Now what happens on survivor's death? It goes out to probate through the heirs at that point. So basically, I will make one comment to you. If you're married, you should not have joint tenancy. You should have community property. Why? There's better tax advantages. But the one advantage of joint tenancy is that you can have your son or daughter on a small account. I wouldn't do a large account. So they have access to that account. Under community property, basically, I would suggest you do community property with right of survivorship. What does that mean? When one of you dies, a husband and wife, when one dies, it goes to the surviving spouse at that point. The advantage of California and about another 10 or 11 other states having community property, we have what's called a full step-up in basis. If you've been married a long time and you have assets that are highly appreciated, one thing to avoid the capital gain taxes is that you wait to a spouse to die. And what happens is that basis, that acquiring price gets stepped up. So for example, if you bought something for $10,000 and it's now worth $100,000, what happens at death is you get a full step up in basis from $10,000 to $100,000. If you turn around and sold it, there'd be no gains. And so the capital gains rate is about 20%. You would forego all that. Plus, state of California is about 10%. So that's about $30,000 or a third of $90,000 basically you can avoid by waiting till a spouse's death. Contracts. Basically, we have a number of entities like this. So basically, we have what's called life insurance. Life insurance goes to a beneficiary. And basically, if one dies, I recommend it go to the trust. You say, Arthur, I want to go to my spouse. Well, here's my example. You have the spouse be the primary beneficiary. You're in a car accident. Husband dies. The wife is in a coma. Who makes that claim on that life insurance? If it's the trust, then the trustee, as we talk about in the future, will basically be able to claim that life insurance. On annuities, for tax reasons, I tend to recommend spouse first, children second. And basically, typically, spouses can roll that annuity over to another annuity if that makes sense at that point. Pensions, I must admit, I'm envious that anybody's got a pension. You don't see too many these days. So if you have a pension, it may stop at your death, or it may continue with your spouse. But when she or he should die, then at that point, basically it'll stop typically. Then we have retirement dollars. And a couple things have happened this year we'll talk about in a second. On IRAs and 401ks and other retirement vehicles, I recommend that you have a spouse first, generally speaking, children second, but if you have minors, we may not want to do it that way. But if you have a spouse, you die, it goes to your spouse, she can roll that into another IRA. If it goes to the children, it used to be that children could stretch those proceeds over their life expectancy. The new rule came into place this year under the Secure Act that they can have to pull it out now as a general rule over 10 years. You may have an account, maybe a bank account called POD, paid on death. Basically what happens here is that you pass away, you have your children or your family or your trust as the beneficiary under that bank account. It goes to those people or the trust itself. On a rare occasion, actually, you can do TOD, transfer on death. I highly recommend this for cars. And basically, you can have a car that you know is supposed to go to one person in particular. You have your name, TOD, transfer on death to that person. And it's relatively simple. You can go get in line at the DMV, or even better yet, go down to AAA, and they'll do it very efficiently for you at that point. So basically, we're talking about how to avoid probate. And the thing is, we're really the foundation of your estate plan should be the living trust. And basically, the living trust is a vehicle that allows you to pass assets. It's a legal arrangement which allows you to maintain control of your own assets during your lifetime and pass your assets to your intended beneficiaries without the need of probate. And that's why we're here. On my workbook, once again, how to avoid probate. We want to avoid that. But there's more than one type of trust. There's called a revocable trust and irrevocable trust. And the typical foundation of most of my clients' estate plans is the revocable trust. What does that mean? A trust that can be altered or amended or revoked, canceled, that is. What's an irrevocable trust? A trust that cannot be altered, amended, or revoked. So as a general rule, there's reasons why you do one or the other, but as a foundation, the starting point reference to most of my clients will be a revocable living trust. So who are the parties involved in a living trust? Well, basically you have the creator. It's called the settlor. Some lawyers call the word trustor. You're the creator, you're the maker. You tend to be your initial own trustee. While you're alive, you're what's called the life beneficiary. So what happens now is that you take your assets and you put it into the bucket called a trust. And what happens is that if you cannot manage your own affairs, then we have what's called a successor trustee. Finally, at your death, the successor trustee reads the terms of trust and has those assets pass out to the remainder beneficiaries at that time. Who should be your trustee? Should that be a family member? Well, the majority of my clients tend to use a family member, and that's sons or daughters. I will say not all my clients have children, or they have children that live abroad, or they have children that are not available, or they have problems. So one of those things we have to discuss, do you have the right family member? You may want to use what's called a private fiduciary. That's somebody who's in the business to step in and take care of people. Also, we have what's called a corporate trustee. Not all banks have a trust department. So basically, one of the things we have to look at is there a good match as to who should step in when you cannot take care of yourself? And remember, if you become incapacitated, someone needs to step in who is responsible to basically take care of you, and then finally, upon your death, pass it on to your heirs and beneficiaries at that point. So a simple living trust is basically you take your assets, you throw them in the trust. Now what happens these days is that at your death, we take a snapshot. And basically, the snapshot says, how large is your estate? Under current rules today for 2020, basically what happens now is that if you're below $11,560,000, you will not have any estate taxes. That means all of the assets go to your beneficiaries without the need of probate or paying death taxes. So there are other types of trusts depending on what we're trying to accomplish. We may have a simple disclaimer trust. We may have a Q-tip trust. We may have a trust for blended families. We may have a skip generation trust or a GST trust. You may have life insurance for the blended family where we're going to make sure that assets do go to his children or her children through maybe a life insurance trust. You may want to do some tax planning and be charitably minded. You may want to do what's called a charitable remainder trust of sorts. We may want to do what's called a Medi-Cal trust. Basically, how do we preserve assets? And there are other trusts out there depending what your goals and objectives are. What are you trying to accomplish? What do we need to do for you at that point? So basically, I will make one comment. It's not just a trust. It's just not a will. You need a comprehensive estate plan. And basically, when you do a trust, you have a poorer will that goes with it. You have a financial power attorney. You have an advanced healthcare directive. You have an assignment of personal property. You want to sweep in the assets that don't have any types of ownership. We also have a property agreement that basically says your assets are, if you're married, separate or community property. So basically, on my workbook, we basically shows how it all works together. My husband and wife clients will do a community property agreement that says all our assets are community property. Or if you're single, we don't need to do that. But if you're single or married, you want to do an advanced healthcare directive. Most people, once again, will do husband first or spouse first or wife first and then the children. We also want to do a financial power attorney. You want to be able to nominate a conservator. Most important, what you want to do is create that living trust that will take care of you while you're alive as well as at death. And basically, you create the bucket, and then you want to transfer assets into the bucket. While you're alive, you get all the income back. You get all the principal back as for your needs. Finally, what happens at your death, we take a snapshot. Are there assets outside of the trust? If you have assets below $166,000, then there won't be a need of a probate, and the corporate will step in and put the assets in the trust, and then finally, ultimately, distribute them out to the children. Now, if they're under 25, will be held in trust till they reach 25, typically, or something else, as we talk about. So where do you go from here? What happens here is basically the need is, once again, please download my workbook, How to Avoid Probate. Basically, you want to avoid that. And what you want to do is have a trust that is right for you. You want to have a smart trust plan that has more than just a trust or will. You want to have, once again, the financial power attorneys and healthcare power attorneys. So what do? Well, you can procrastinate. It's easy to do these days. You can try to do it yourself. You can look online. I will say that I have a trust that I've been working on and tinkering with and modifying over the last 33 years as well. You work with others. Be careful you don't end up in a trust mill. They're trying to sell you something else. Make sure the person is, I would recommend, a certified specialist to work with. Someone has that experience. So basically, who's that type of person? How about us? We're conveniently located in Carlsbad, California. We're a small office. We're very efficient. That's all we do is estate planning. You will not be a number with us, basically. And we do offer a complimentary consultation at this point. We will tailor an estate plan to your specific goals and needs. Basically, we got to discuss with you. Some of you have a trust right now, and we need to review what you have. And basically, on the confidential questionnaire, we'll ask you to basically fill that out, and we get to review what you have. And I will ask you questions. Typically, we really like it face-to-face, and I'll ask questions you probably never even thought about before. And that's part of my goal, is to basically address things that are for today and tomorrow and beyond. So my typical fees are about $3,500, $3,600, depending who we're talking about. I do offer, as part of my free complimentary consultation, a $200 discount because I spend typically a half an hour of time with people just educating them. Well, I don't need to educate you as much because you just spent a half an hour with me or so. But I do say I greatly appreciate the opportunity to have you come in and take advantage of an action. I will say I cannot oversee or have to discuss about COVID. I will turn this back over to Ruby, who will address what's going on in my office right now. Thank you.
Hi, everyone. Thank you again for attending our educational webinar about essentials of estate planning. As I stated earlier in the beginning of our presentation, the two main reasons people hold off on coming in for estate plan is, one is procrastination, and that is what Attorney Brown addressed, why you should not procrastinate, gave some really great examples of why you need to come in. And with this whole COVID-19 pandemic, one of the lessons that it's taught us is not to procrastinate, that we want to have our affairs in order. And we've been taking precautions to make sure that when you come in, that we are offering a clean and safe environment. We are limiting our appointments. That way clients do not cross over each other when they come into the office. Our lobby is closed. Our restroom is closed. We have traded out our beautiful leather chairs for lovely steel chairs so we can sanitize them after every appointment. And we all wear masks during our or facial coverings during the duration of their appointment. Furthermore, the second reason why people didn't have an estate plan is because they didn't think they had enough assets to create one. Again, that's what Attorney Brown pointed out earlier about our confidential questionnaire. As you'll see on the handout section on the right side of your screen, you can download that confidential questionnaire and fill that out. And when you bring that in for your complimentary consultation, Attorney Brown will assess that for you, and we will tailor an estate plan that's specifically for you, that meets your needs and your wishes regarding the legacy that you want to leave. You can go ahead, and if you didn't click on the call to action to schedule that complimentary consultation, you can always go to our website at whiteprobate.com, and you can schedule it there as well. Give us a contact, give us an email, or if there was a question that we didn't get to in this during this webinar, you can always ask it to us there as well too. Thank you very much.